Hello everyone, my name is Kevin. Today I'm making a presentation for BUS393 D204. My topic is negotiation a more beneficial way than litigation or going to the court in business disputes? First of all, I would like to explain why I choose this topic. When talking about commercial law, the first thing that comes to my mind is negotiation and litigation. Besides, I always heard that many adults around me talk about the hardship of work since I was a child. Of course, this is partly due to the nature of the job itself, but it is more likely caused by the inequality status between companies and individuals. Sadly, many times they can change the status for various reasons. Here, I would like to use this presentation to seek a more suitable solution for both companies and employees when facing a business dispute. My presentation can be divided into 5 main parts, which are definition, pros and cons, case analysis, suggested solutions, and references. So, what is litigation? Litigation is the term used to describe proceeding initiated between two opposite parties to enforce or defend a legal right. Litigation is typically settled by argument between the parties, but may also be decided by the judge. Contrary to popular belief, litigation is not simply another name for a lawsuit. Litigation includes any number of activities before, during, and after a lawsuit to enforce a legal right. And what is negotiation? Negotiation is a process where two parties in a conflict or dispute reach a settlement between themselves that they can both agree on. Negotiations are reached through discussions made between the parties on their representatives without any involvement of the third party. Each party should consult or see a lawyer before settling down the matter, so that they are well aware of their rights and duties in respect to the matter or dispute they are willing to solve. Okay, now we have a clear mind of what litigation and negotiation are. The next step is to understand the pros and cons of litigation and negotiation. Litigation has 4 main advantages. The first one is parties are compelled to comply with judgments. Due to the nature of the Canadian justice system, judgments obtained through litigation force parties to comply or run the risk of being given specific penalties. As such, the losing party in litigation is likely to comply with the judgment that is pronounced against it. The second one is right to appeal. Canada's justice system allows either party to a lawsuit to ask an appellate court to receive the trial court's decision should one of the parties disagree on it. The third one is precedent value. When litigation goes through the courts, it provides lasting benefits in the form of precedent. That means parties can point to previous ruling in similar cases and use that precedent to support their argument. This is an ever-present advantage of litigation, as it allows to speed up dispute resolution where similar claims are made. The fourth one is result. It is one of the most obvious benefits of litigation. You will eventually get a result no matter how long it takes. When ADR can break down, litigation is your last and most conclusive hope of resolution or closure. Litigation also have 4 main disadvantages. The first one is longer time frame. Sometimes, depending on the issue complexity, cases can take up to several years to be decided by the court. Second one is costly. The litigation process can undoubtedly become quite costly with legal fees and other costs associated with the trial. The cost of litigation will also arise by the length of pretrial period as well as the length of the trial. The third one is damaging relationship. One of the downsides of taking a case to trial is that it is almost always damaging to the two parties' relationship. Thus, it can be very challenging for both parties to preserve any sort of relationship once a judgment has been handed down. The last one is public forum. The risk of taking a case to trial is the possibility that it will attract public attention, as most court documents are available publicly. Negotiation also has four main advantages. The first one is flexibility. In procedural terms, negotiation is probably the most flexible form of dispute resolution as it involves only those parties with an interest in the matter and their representatives, if any. The parties are free to shape the negotiation by their own needs. The second one is voluntary. Negotiation is a voluntary process. No one is required to participate in negotiation should they not wish to do so. The third one is inexpensive. In most cases, negotiation instead of litigation is less expensive for the parties and could reduce delays. The fourth one is promote relationship. Negotiations may preserve and even enhance the relationship between the parties once a win-win agreement has been reached between them. Negotiation also has four main disadvantages. The first one is it heavily rely on bargaining power. A negotiation may be a successful outcome. However, parties may be of unequal power, and the weaker party may be disadvantaged. When a party with interest in the matter in dispute is excluded or inadequately represented in the negotiation, the agreement's value is diminished, thereby subject to further challenges. The second one is no compulsion. No party can be compelled to continue negotiation. Anyone who chooses to terminate negotiation may do so at any time in the process. That means time, effort, and money that have been already invested can be wasted. The third one is hard to reach agreement. The absence of a neutral third party can result in parties being unable to reach an agreement, as they be or may be incapable of defining the issue at stake. The last one is dishonesty. The negotiation process cannot guarantee the good faith and truthfulness of any of the parties, for there is no third-party supervisions. It seems as if litigation and the negotiation have their own merits, but in different situations, the discrepancy between them are obvious. Thus, I set up three different situations to analyze. The first situation is individual versus company. I choose Mr. Hisip's case as example to determine whether litigation or negotiation is the best solution in this situation. Mr. Hisip was offered a position at Imperial Oil Limited. After learning that Mr. Hisip was not a Canadian citizen or a permanent resident of Canada, Imperial rescinded the job offer. At the time, Mr. Hisip had a student visa and planned to obtain a postgraduate work permit for 3 years. However, he did not meet Imperial's requirement that candidates be eligible uh, candidates uh, requirement candidates be eligible to work in Canada permanently. The Ontario Human Rights Tribunal found that this requirement was discrimination based on a prohibited ground of citizenship. The tribunal concluded that had Imperial not violated Mr. Heath's rights, he would have been hired and would have been worked for at least 3 years. Mr. Heath finally awarded compensation totally for over $100,000 for his lost income for the entire period of unemployment. Mr. Heath also obtained a reward of $15,000 for injury to dignity, feeling, and self-respect. Imperial ultimately had to pay Mr. Heath over $125,000, a deep price for the requirement that candidates be eligible to work in Canada permanently. So here's my analysis. Compared with the company, the limited funds, time, and bargaining power of individual leads to a disadvantage in litigation process. Regardless of the law's fairness in Canada, its success rate is not that high. That is why not many people do lawsuit to the company. Besides, many times the compensation you get doesn't make up for your loss. Mr. Heath mentioned in the previous example is indeed compensated, but the compensation for time, energy, reputation, and potentials is far from enough. These intangible things are difficult to measure with money. And because punitive compensation is barely used in commercial disputes, compensation is less than what is paid. In contrast, if this gentleman and the company are negotiating, at least the cost of lawyers and the time consumed can be significantly reduced. Besides, after entering the company, the relationship with employer will not be too bad. Thus, in this case, negotiation is the best solution. The second situation is collective versus company. I choose RCMP's case as example to determine whether litigation or negotiation is the best solution in this situation. The RCMP began officially accepting female recruits in 1974. However, unfortunately, since that time, female officers and non-policing staff and volunteers have suffered sexual harassment, abuse, and discrimination at the hands of their male colleagues. Over 3,000 female officers joined a class action case against the RCMP, another class action for civilian employees and volunteers incorporate 41,000 claimants. The claim brought by female officers against the RCMP was initially settled for more than $100 million in 2016. However, 3 times as many women submitted claims for compensation than expected. The amount available was increased to $150 million. Another class action lawsuit seeking compensation for women in non-policing roles was settled in 2019 for more than $100 million. Here's my analysis. From the individual to the collective, the companies, their bargaining power has been greatly improved so that the companies has to compromise in the negotiation. Companies usually adopt delaying techniques to maintain their profits, such as the strike of BC TransLink last year. Besides, it also minimizes the impact of public opinions on the company. Although the risk of litigation is very high, the possibility of winning a litigation is considerable. due to its strong bargaining power and social resources. In addition, due to the plaintiff's collective nature, once the litigation is won, the punishment for the company will be greatly increased. In other words, the individual's share of compensation will also increase accordingly. As mentioned above, RCMP has compensated a total of more than $250 million. That's a lot of money. In contrast, it is difficult for negotiation to obtain that much money as compensation. Thus, in this situation, litigation is the best solution. The third situation is company versus company. I choose a Canadian Goose case as example to determine whether litigation or negotiation is the best choice in this situation. Canadian Goose is a company that has sold more than $225 million in coats and accessories across Canada since 2005. Recently, it has launched a lawsuit against Sears, accusing the department store of selling knockoffs of its highly distinctive parkas. The jacket marker has filed a trademark infringement lawsuit in federal court. CS is initially seeking to mislead customers and potential consumers into believing that they are purchasing a lower-end Canada Goose jacket that is intended for sales at Sears. Canadian Goose right in the claim. So here's my analysis. Whether the business dispute between companies are through negotiation or litigation depend on situation. If the dispute involves the company's core value, it is necessary to do litigation. Once the company compromises in negotiation, the company will lose its core competitiveness, just as the copyrights mentioned above is for Canadian Goose. At the same time, it is also a means for company to establish prestige and reputation. The more competitors are, the better they are not. Besides, companies, especially large companies, may become rule breaker to create the precedent for the law. So companies cannot adequately predict the result to avoid risk. Thus, in this situation, either litigation or negotiation could be the best choice. And the outcome from the analysis above shows no regularity. We need a quantitative solution. So I created a quantitative table of business disputes to make a better and more precise choice between litigation and negotiation. The first row of this table is the deciding factor that I extracted from the three previous cases. The leftmost column is the degree of satisfactory from highest to the lowest. This table has 5 determinants, each with 5 points, for a total of 25 points. As long as it is greater than or equal to 13 points, it is more advantageous to choose litigation in business disputes and vice versa. Besides, the proportion of each decisive factor can be adjusted under different circumstances. For example, when you are an individual in a business dispute, you can raise the weight of physical resources. When as a collective in a business dispute, You can raise the weight of bargaining power and the social impact. Uh, when as a company in a business dispute, you can raise the weight of core value and the rule breaker. Here's my reference for the presentation. Thank you for watching my presentation. This is the end.